Hi, thanks for joining me. I'm Jared Pearson. Today we're going to be discussing minor settlements in car accidents. The fact that you're going to need judicial approval for any minor settlement in North Carolina is a big factor. I want to run through what that's going to mean for your case if your case involves a minor in North Carolina. So first things first, we're going to be discussing your injured minor can bring an action in North Carolina so long as it's through a GAL. GAL stands for guardian ad litem. A guardian ad litem is a appointed representative by the court for the purposes of representing that minor's interests before the court. Secondly, minors will typically be able to seek damages for pain and suffering, permanent injury, and loss of ability to earn income. It's quite rare for the minor to seek medical reimbursement or reimbursement for their medical expenses. That claim is typically reserved for the parents. However, it is possible for the parents to assign that to the minor for the purpose of presenting the claim. That's pretty advanced stuff, but what's important to remember here, if you're an injured minor or if you're representing an injured minor, you're going to need appointment of a guardian ad litem or a GAL as it's commonly referred to represent that minor's interests. Let's move on. Secondly, judicial approval is required in the state of North Carolina for any minor settlement. So if you have a minor that's been involved in an accident and that minor is seeking a settlement of their claims against the at-fault party, a judge will be required to approve that settlement, or the settlement could be abandoned by the minor upon reaching the age of 18. Let's go through and discuss what this is going to mean if you're representing a minor, or if in fact you're 17 and you just want to know what's happened to you, or you're close to being an adult. With that being said, a settlement of a minor's claim is not enforceable unless two things happens. It's been investigated by the court. We're going to discuss what that means in just 1 second. And two, it's been approved by the court. So most people, when they talk about this process, they talk about the approval of the court. Judicial approval is required, but they don't talk about what judicial approval is. And that's the first prong of this. It has to be investigated by the court. The court has to have a say in looking at the facts, and we're going to get into exactly what that means in just one moment, but bear in mind that for a claim to be enforceable or a settlement to be enforceable for a minor, investigated and approved by the court. There's a really good case here. See it if you want to see it. Don't see it if you don't. Ballard v. Hunter, North Carolina case from 1971. Very instructive and very helpful to understanding what minor settlements are in North Carolina and how they work. With that being said, even if the minor settlement was handled by the minor's parents, by the guardian ad litem, the GAL, and the minor's attorney, if a judge does not approve the minor settlement, the minor does not have to be bound by that and can disavow that settlement upon reaching the age of majority, which is 18 in North Carolina. So it's important to understand that if you're a minor, if you've reached 18, you've got funds sitting in the trust account at the county clerk's office, or maybe it's been put into some kind of settlement or an annuity for you, if it wasn't approved judicially, if a judge didn't hear your case, if you never went to court, and you don't recall that, double check, make sure that a judge approved it, but bear in mind that it is critical that if a judge doesn't hear this, if a judge doesn't approve it, it could be disavowed. Let's move on from there. I'm sure you're going to have a lot of questions about this. I'm trying to make it as simple as possible. These are short videos to try to be illustrative and explain to you what the point and what this is and what it isn't. Let's move on right here to what does the court investigate? This is a critical component of the two-pronged test of investigation and approval. When the court begins the process, there's typically a friendly lawsuit filed. The minor, through a guardian ad litem and a lawyer, sometimes not a lawyer, will sue the at-fault driver, or they have reached a settlement, and that settlement will be presented to the court for approval. So the court doesn't have a defined way of verifying or validating or investigating a settlement. The court is acting in their own discretion. They've got their own processes, and it's very factually intensive, and it's very factually dependent. It's going to depend on the kind of case you have, and it's going to depend on the facts and circumstances surrounding that case of what the court's going to do. However, there's some basic lessons we can take out of what's happened in the past and some of the case law. Let's move on. Judges and local rules often require the minor to be present at the minor settlement, but the guardian ad litem and or the lawyer, if there is a lawyer, will have to be there. It's a good rule of thumb to bring the minor with you to the hearing so the judge can do the vetting the judge is going to have to do in order to determine the facts and circumstances in the present case. Bring the minor, bring the guardian ad litem, and obviously if you're the lawyer watching this, you got to be there and you should know that. Third, here's some key considerations that you're going to want to consider if you have a minor settlement coming before the court for approval. Here's some of the things the court's going to look at. First, the court's going to look at the strengths and weaknesses of the case at hand for the defendants as well as the minor plaintiff. The court will look at the facts and circumstances, use its discretion to weigh those strengths and weaknesses of the case. Secondly, the court will consider possible defenses that the defendant may have in the minor plaintiff's action. Third, the burden of litigation on a minor. This is a factor that's not often considered by lawyers when they're taking their minor child who's of tender age at 3, 4, 5 years old before the court, and you're trying a case. Can that minor child testify why they ran into the road and got hit by a car? Will the minor be deposed? What is the burden on the child that's involved in this case? The court is absolutely going to consider that. Some may consider that the best interest of the child standard, although that really doesn't exist in our case law or in statute. Fourth, the extent of the injuries and the permanency of the injuries to the minor child. The more egregious the injuries, the more the court's going to want to hear about it. The court may ask for medical evidence and medical testimony. The court's going to do a deep dive into those facts because that's going to be a big part of whether the court's going to approve that settlement. Number 5, the defendant's coverage and the defendant's ability to pay is going to be considered if the settlement's going to be approved. That's going to be a very small factor in my opinion, but definitely a factor that's going to be hot on the judge's mind. Number 6, the terms of the settlement. How does the minor get paid? When does the minor get paid? Who's going to hold the funds? How often the GAL can come and ask the court for release of those funds if those funds are held by the clerk. Those are going to be big factors, as well as making sure that the GAL and the parents, who are often not the guardian ad litem of the child for the purposes of this situation, how often they understand or how they understand that they can't come and just take money from the minor's settlement. This is a process to protect the money for the minor so they can get that money when they're 18. Very few circumstances allow the parent to come and get that money ahead of time. With that being said, the court will also investigate any liens or any subrogation interests under federal and state law, whether it's a 4449 lien or whether it's an ERISA lien that may exist against the medical expenses. That's a factor that will often be more important if the medical expenses have been assigned from the parent to the minor child. Number 8, the eligibility for government benefits after the settlement has been approved. For example, if a child is currently a Medicaid recipient and receives a large settlement, will that child still be eligible for Medicaid benefits after the settlement? The court should definitely be looking at that, and if you're a lawyer and you're watching this video and you aren't considering that, you could be making a gravest mistake for your child. Number 9, how the minor child will get paid, will it be held by the clerk or go into an annuity, is a small part of the equation, but an important part of the equation you should be considering, and the court will definitely look at it as well. Last but not least, there is more. There are very many factors the court will look at when it comes to how they will look at the facts and the circumstances surrounding what's taken place. If you are representing a minor child and you're an attorney watching this video, have a good understanding of what's happened. Understand the facts and circumstances, understand the medical records, understand what the doctors have said, and know your client. The judge is going to ask a lot of questions. If you're the parent and you're coming with a guardian ad litem, be prepared to talk as well. Even though you may not be a guardian ad litem or the attorney or the minor, the judge may want to hear from you. So, if you have questions, feel free to reach out to us. We're here to help. If you've watched this video and you've got more questions and answers, shoot us a message. You can reach out to us at Twitter at WPLNC. We're happy to answer your questions. We'll keep making these videos if you keep watching. I really appreciate you joining us. We hope you've learned something. Have a lovely day.